Namaste, Sada Khush Raho Betiya. I, Jv'n Dr L K Sharma, Professor Jyoti Vidyapeeth Women's University, Jaipur. Today our topic is extraordinary remedies. Article 226 empowers the High Court to issue to any person or authority, including the government, in appropriate cases, directions, orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, certiorari, or any of them. The first one is habeas corpus. The habeas corpus is a Latin term which literally means to have the body of. It is an order issued by the court to a person who has detained another person to produce the body of letter before it. The court will set the imprisoned person free if the detention is illegal. This writ is a bulwark of individual liberty against arbitrary detention. Second, mandamus. It literally means we command. It is a command issued by the court to a public official asking him to perform his official duties which he has to fail to perform. Third one is certiorari. Literally the certiorari means to be certified. The writ of certiorari can be issued by the Supreme Court or any High Court for quashing the order already passed by an inferior court, tribunal or quasi-judicial authority. There are several conditions necessary for the issue of writ certiorari. There should be a court, tribunal or an officer having legal authority to determine the question with a duty to act judicially. Such a court, tribunal or officer must have passed an order acting without jurisdictions or in excess of the judiciary authority vested by the law in such court, tribunal or officer. The court could also be against the principles of natural justice, or the order could contain an error of judgment in appreciating the facts of the case. Fourth one, prohibition. The literally meaning of prohibition is to forbid. A court which is higher in position issues prohibition writs against a court which is lower in position to prevent the latter from exceeding its jurisdiction or usurping a jurisdiction that it does not possess it directly, inactively. Quo warranto. It literally means by what authority or warrant it is issued by the court to inquire into the legality of the claim of person to a public office. Therefore, it prevents illegal assumption of any public office by a person. Injunction. It is issued by a court as a kind a person to do things or refrain from doing it. Thus, it is of two kinds, which mandatory and preventive. The mandatory injunctions resemble the writ of mandamus, but it is different as put by MP Sharma. Mandamus cannot be issued against a private person, while the injunction is primarily a process of private law, only rarely a remedy in administrative law. Mandamus is a remedy of common law, while injunction is a strong arm of equity. Similarly, the preventive injunction resembles the writ of probation, but it is different. In the words of MP Sharma, injunction is directly to the litigant parties, while probation to the court itself. Also, while injunction recognizes the jurisdiction of the court in which proceedings are pending, prohibition strike at such jurisdiction. This is all about the extraordinary remedies in the sense of writs issued by the high courts for the protections of the rights of the Indian citizens. Thank you. If you're facing any problem, write down a comment in comment box. Thank you.